Day, and we'll call the next case if the parties are ready. Cocoa Beach, Oceanside versus Clarke. Good morning to you both.
Hi, good morning.
Give council just a minute to get organized, sure, and then we'll get started. All right, thank you.
Good morning, Your Honors. Kristen Tajak with Cole, Scott, and Cassane on behalf of the appellant, Oceanside Inn. I'd like to, if I may, reserve 5 minutes for rebuttal. Thank you. Your Honors, this is an appeal from a jury verdict entered in favor of the plaintiff, Mr. Clarke, in the underlying action. We would ask on appeal that this court find that the trial court erred in failing to grant a new trial both on liability and damages. And I would like to initially point out that we concede that the issue of liability was not properly preserved by way of a directed verdict. However, in our new trial motion, we did properly preserve the issue of the insufficiency of the evidence. And so we would ask on appeal that this court grants a new trial on liability and on damages.
How do you distinguish this case? I understand that your client testified. We take good care of our hotel. We paint it regularly, we clean it every day, and we have air conditioners that don't leak. But in the real world, things that aren't supposed to happen, happen. I mean, pipes in my house break that aren't supposed to break, things leak, I mean, it happens. And so we have the testimony from your client that says, you know, we take great care of the place, it's not supposed to leak. And we have the testimony from, I guess it's Mr. Clarke's girlfriend and the photographs that show what appears to be water leaking, and that it appeared to be slimy, which I guess would be indicative of, I guess the inference is that it's water that has been there long enough that it got slimy. I mean, why isn't that enough? Just on the question of liability in a slip and fall case, why isn't that enough?
Well, I think the problem with that is that it leads to a stacking of inferences. There was insufficient evidence to demonstrate initially that there was water in fact leaking from the air conditioning unit.
Well, you got her testimony that said there was water that appeared, and I looked at the pictures. I mean, it looks like there's water coming out of the air conditioner.
Yes.
I mean, I recognize your client said it's not possible, but you know, the pipes in my house aren't supposed to leak, but it happens.
Yes, but the first inference is that that was caused by some sort of negligence on the part of the hotel, or, you know, not that it was from rain that had rained and water.
But again, you had one client,
that
you know, you had your client saying it was raining cats and dogs, and they're saying it was just as sunny as it could be. So, I mean, apparently.
Well, I think that that's the first inference, is that was the water leaking from the air conditioning system, or was it some other cause?
Well, is that an inference if you have testimony that I saw water leaking from the air conditioning unit? I mean, that's not an inference. Isn't that direct testimony?
Yes, but there was conflicting testimony, and certainly a question of fact would be left to the jury's determination.
And so the jury could conclude from the evidence that on that day in question, the air conditioning was leaking.
Yes. And
as a result, there was water on the balcony, and the jury could find from the evidence appropriately that the plaintiff slipped and fell because of that water. That would all be something that the evidence would support. Now, if it started leaking that day and your client had no notice of it and had checked the day before and there was no leakage, then I guess an argument could certainly be made that there's no proof of negligence.
Right, and I think that's the next inference that would have to be made.
And can the jury find that if they accept the the testimony that it was slimy, that it had been there a while, and your client testified they checked every day, and if the slime indicates that the leak had been there for a while, would that be, whether it's an inference or what, would that be sufficient for the jury to find liability?
Well, I'm not sure exactly what slimy means. It could have been there for overnight and become slimy. We don't have any testimony in the record as to how long it would have had to remain on the balcony to become slimy.
Do you need expert testimony on slime? Or
well, I mean, I'm not sure how long would be an inappropriate amount of time for it to have been remaining there. Obviously, there's testimony from the hotel that the rooms were inspected every day, that there was no water there. Mr. McGee, the hotel owner, testified at trial that he went there when he got to the hotel later that day, and the balcony was dry. He inspected the balcony. It was at that time dry. There was no leakage from the air conditioning system when he inspected it. They took a number of other precautionary measures, painting the balcony twice a year with paint that contained sand in it to avoid slippage.
I mean, this is all a great closing argument, but it seems to me that based upon the evidence, the jury accepted their version instead of your version. So my question, though, is it a reasonable inference? I agree that if this was the first time that air conditioner had ever leaked and they had inspected it every day for the last 2 years and it had always been perfect, then the leak probably wouldn't have been there for a long enough period of time to put them on reasonable notice that there was a problem.
Well,
but they've got this lady saying it was slimy. So the question then becomes, and I think it is an inference, what reasonable inference can the jury draw from the slimy testimony?
well, I
I mean,
think
is that do you really think that that's something that would require an expert? You got to bring in a slime expert and say, well, the water has to sit there. You know, if the ambient temperature is 80 degrees and it's on concrete, it's got to sit there for 3 days before it'll get algae will grow or something. I mean, or is that something that everybody who's ever mopped the floor and had a leak in their house would get to know by common sense?
Well, Your Honors, I really think that it still leads to a stacking of inferences. The mere fact that the water was slimy doesn't necessarily demonstrate that the hotel had notice of that.
Well, you don't have to have actual notice, that you knew or should have known. So you don't have to actually know it. It's whether you should have known by reasonable care, right?
That's correct. That's correct. And all of the evidence demonstrates that the hotel took all kinds of reasonable measures to ensure the safety of its guests with regard to the balcony. And these air conditioning systems were less than 3 years old. They were maintained regularly. They were anti-leaking systems. The hotel clearly took proper measures to ensure the safety of its guests. Also, Mr. Clarke and his girlfriend never looked out onto the balcony prior to stepping out that morning. So they have no way of even testifying that the water had been there for any length of time. It could have rained early that morning while they were still sleeping and led to a puddle of water on the balcony. It's also a beachfront, oceanfront property, so there's an issue with salt water from the ocean, and the hotel, maintains the balconies daily and cleans them to ensure the safety of the guests. But certainly that's another inference that could have been made, that water from the ocean caused the puddle on the balcony.
Do you want to get to the issue of the future earning capacity, because you contested that, and I'm not exactly sure that.
On the future earning capacity?
Pardon?
Yes, correct.
All right. Explain to me why
Sure.
you think that wasn't adequately established.
Well, there was insufficient testimony in the record at trial the only testimony came from Mr. Clarke himself on that issue, and he was unable to testify with any degree of reasonable certainty as to what his prior income had been. The only testimony was that the year prior to his accident, he had earned approximately $67,000, $76,000, $50,000 or $60,000. There was inconsistent testimony about exactly what he was making that year. And there was no testimony as to any prior earnings in the past. He worked as a flooring installer for about 10 years and had his own business, but he had no expert testimony or an accountant to testify as to his past earnings, and he actually stated during his deposition that he would be unable to give any sort of...
Would the record of his past earnings be some evidence as to what he would earn in the future? And was there evidence as to what he had earned in the past?
There was evidence as to what he had earned in the past year.
Okay.
Prior to the incident.
Would the jury be able to take a look at what his earning record was in the past and determine with reasonable certainty what his earning capacity would be in the future just based on what he'd earned in the past? Isn't that always a pretty good predictor?
Well, not in this case, Your Honor, because number one, Mr. Clarke worked as a flooring installer, and his salary was not consistent, as he testified. It was based on what kind of jobs he had at the time. Some years may be good, some years maybe not so good. When the accident occurred was 2007. It was kind of the height of the market, and he testified at trial that, after this happened, the market did in fact decline, the real estate market, and that is what his business was based on. So it's a very difficult thing, I think, for the jury to have gauged what his future earnings would have been. And more importantly, I think that there was no testimony from either of the medical providers that Mr. Clarke could not ever work again. This job may have been difficult for him because he had pain in his arm and it was physical type work, but there was no testimony from any doctor in the record demonstrating that he was unable to work at all in the future. In addition...
He was fairly close to the retirement age, wasn't he?
That's correct. He was 60 years old at the time of the accident, and there's testimony that he worked for about 6 months following the accident. He continued on his jobs that he needed to complete, and then at that time he retired. So he did work for about 6 months following.
Well, don't you think 60 is pretty old? I mean, Judge Sawai and I are knocking on that door. I mean, we're barely able to sit here, let alone put in floors. I mean, you can't expect a 60-year-old to work very hard, can you? I don't expect you.
Well, my question was, wasn't it reasonable for the jury to take a look at what he'd done in the past and his testimony that, I'd worked 6 months and just couldn't do it anymore, and he was close to retirement anyway, and just take the retirement age and just kind of plug it in and come up with a figure, and that would satisfy the reasonable certainty test, expressed by the Florida Supreme Court for future damages, economic damages. Wouldn't that be sufficient?
I don't think it would be sufficient because his only testimony was that there was inconsistent testimony that he gave. It was inconsistent all across the board, and so I think it was difficult for the jury to gauge what he may have made, how much longer he would have been working, and certainly the award of $244,000 for future earnings, I think, was clearly excessive in light of that evidence. Your Honors, the third issue that we have argued on appeal is that a new trial on damages should be granted as to the jury's award for future medical expenses. And the issue with that is that the jury awarded $50,000 in damages for future medical expenses. However, the testimony of both of the doctors does not support that award. The first doctor, Dr. Brooks, testified that Mr. Clarke would need some physical therapy going forward. The amount of that was about, I believe, $1,500 a year. It totaled to about $28,000 over the course of his life expectancy. The other doctor, Dr. Godleski, testified that he would actually need hand surgery, and as part of that, the continued physical therapy.
I thought he testified that he would need rotator cuff surgery at $20,000 to $25,000, and he might need hand surgery, and there was no price given for that.
I believe that Dr. Godleski's testimony was that the restorative surgery, for all of the restorative surgery that Mr. Clarke would need, it would be a total of $20,000 to $25,000, and that was inclusive of the physical therapy and hospital expenses for those surgeries. And there was no testimony that he would need both of those treatments. It was either the cost of the surgery outlined by Dr. Godleski or the physical therapy recommended by Dr. Brooks. However, the jury awarded $50,000 for both of those treatments when, in fact...
I mean, did any of the doctors, and I don't know if the plaintiff called both of the doctors or you called one, but did any of the doctors say he either needs the PT for the rest of his life at $1,500 a year, or if he has the shoulder surgery, he'll be good to go at $25,000? I mean, did anybody ever come out and clearly say, well, he either needs this one, $1,500 a year for the 18 remaining years of his life, or he needs the shoulder surgery, but he doesn't need both? Or was the jury sort of left hanging there and could have said, and I don't know if I would have said it, but could they have said, well, we think he will need both, or we don't think that... Now, I didn't really see that the testimony regarding the hand surgery was quite as clear as... I thought that the testimony was that it was $20,000 or $25,000 for the shoulder, and that the hand may or may not... I didn't see that was involved, but your recollection's probably better than mine.
Especially given his age.
But specifically, to come back to my question, did any of the doctors specifically say he needs this or that, but he won't need both?
No, they did not. However, Dr. Godleski's testimony was clear that the total for restorative surgery would be $20,000 to $25,000, inclusive of the surgery, the hospital fees, the ongoing physical therapy needed, because likely after the surgery is done, the physical therapy is not going to be a lifelong process, as Dr. Brooks's testimony suggested, or his recommendation suggested. I see I have just a few minutes left, so I'd like to reserve it for rebuttal if I may. Thank you.
Certainly. Thank you so much.
May it please the Court, my name is Bill Rogner, and I represent Mr. Clarke in this case. Your Honors, in reviewing a denial of a motion for a JNOV, this Court reviews the evidence and all the inferences that could be taken from the evidence in the light most favorable to the non-moving party, and in this case, that's my client.
Let me ask you on the last issue. There's testimony the cost of the surgery would be $20,000 to $25,000. And there's testimony that cost of physical therapy would be, I think it was $1,500 a year, and life expectancy of 18 or whatever it was. What was the evidence to the jury whether this was an either or whether it was a both?
I don't think there's unambiguous evidence either way, but let's look at that. Their argument is that as a matter of law, it was one or the other. It could not have been both, okay? And we're talking about two doctors from two different specialties. First, we have Dr. Brooks. Dr. Brooks is a pain management doctor. He's the one that said $1,500 a year. For what? Physical therapy, pain management modalities that he's going to need for his chronic pain for the rest of his life.
Chronic pain from where? Shoulder, hand?
Well, he has a herniated disc in his neck. He's got a hand injury that has not yet even been evaluated by a hand surgeon, although the other doctor, Dr. Godleski, says he needs to see a hand surgeon and he may need hand surgery, and from his shoulder injury. Then we have Dr. Godleski. He's an orthopedic surgeon. He's going to do one thing and one thing only. He's going to do surgery on that shoulder, and that's between $20,000 and $25,000 a year. I think it's a reasonable interpretation of the evidence that these are not either-or propositions. He's not going to just get shoulder surgery and that's going to be it. He's going to be fixed. I think he needs both. And if you look at the number, that's what the jury did, because Dr. Godleski's testimony is it's 20 to 25. Dr. Brooks's testimony is that it's 28, and so we've got a range of between 48 and 53, and they awarded $50,000. It's perfectly in accordance with the evidence. Judge Orfinger, you asked, or maybe it was you, Judge Evander, you asked opposing counsel, well, you're making a great argument for closing arguments, and that's their entire brief. Their entire appellate argument is an argument about argument that's appropriate for a jury. Let's again talk about the liability issue. They claim, what they say is, it's common knowledge that an oceanfront balcony will be slippery from rain, ocean water, or other ordinary condition. But that's not this case. It's not this case at all. This is a case about an air conditioning unit with no drainage system being put to use in hot, humid, summertime Florida conditions, and a trail of water that went from that air conditioner across the balcony, and it was there for a sufficient period of time to become slimy and to discolor the surface of the balcony. I mean, you referenced the photographs. The photographs don't show rain. They don't show ocean water. They show water dripping from the air conditioner and running across the balcony. They show discoloration of the surface, and the only witness that testified about that surface testified that it was slippery and slimy. And you asked about whether we need an expert to talk about whether it's slimy or not. Well, the Abdin case, cited in the brief from this district, says that the consistency of a surface, whether it's slimy and slippery, is subject to lay testimony. And it's comprehensible by the average juror. And we do not need expert testimony to establish that. And this is, they say, well, there's no evidence of how long it was there. Yes, there was. There was circumstantial evidence of how long it was there. And the circumstantial evidence is the sliminess of the surface, and the circumstantial evidence of the photographs showing the discoloration of the surface. And I cited no less than 10 cases in the brief that stand for the proposition that a jury can use just such circumstantial evidence to impute constructive knowledge to the defendant, which is what they did in this case. And again, they talk a lot. They talk a lot about the airtight, ironclad inspection procedures that the defendant testified about. But there were two witnesses that testified. One was the maid, Ms. Diaz, and she testified that she had no recollection of ever inspecting that particular room. And then we have Mr. McGee, the owner. And he said, my air conditioners can't leak, it's impossible. Really? This is Florida. Every air conditioner drips. These air conditioners were designed with no drain hose. They were designed that way. Then he says, I insist on perfect cleanliness, and we inspect every room every day. But the jury had ample reason to reject that testimony as not worthy of belief. For example, he said, well, the reason it may have been wet is it was pouring down rain that day. It was raining so hard, I couldn't even go to work. Well, Mr. Clark and Ms. Norris both testified. Bright, sunshiny day, not a cloud in the sky. He's confronted with that evidence, and he's shown the photographs. And he says, okay, all right, maybe it wasn't the rain. It must have been that the maids, when the maids clean the windows, they use a lot of water. Of course, my client checked into the hotel that evening with his girlfriend. They spent the entire night in the hotel, and the accident happened immediately upon waking up the next morning. The maids weren't in there in the middle of the night cleaning those windows. So he gave the jury plenty of reason to disregard his testimony. Now, the second issue, which involves the loss of earning capacity, of course the jury can take his earnings and project out future. That's reasonable. That's in accordance with case law. Their criticism is that he did not have an accountant or tax returns or something to clearly document exactly how much he'd earned in the past. And he did give different numbers. Now keep in mind, he's not you, Judge. He's not me. He doesn't get a salary. Okay? He's a flooring installer. Their wages go up and down. And he said, well, look, some years I make 60, some years I make 70. I make $1,200 a week, I made $1,800 a week.
Well, do you say some years, or did he say last year I made 67, and then 76, and then it was at least 50?
Right.
Was he focused on some years or last year?
Your Honor, I don't know that the testimony's that clear. He did use the word last year, and what he said was, I know I made more than $50,000. Okay?
Well, I'm trying to accurately reflect what the record is, and you said if I understood you correctly, that he testified, some years I make this, some years I make that. But I thought all of the testimony was with respect to last year.
I think that may be accurate, Judge, that the focus of the testimony was the previous year. But what he said was, look, sometimes I make $1,200 a week, sometimes I make $1,800 a week. He conceded he wasn't 100% sure, but let's look at this. The lowest figure that he gave, the one that he said, I'm certain that I made at least this, was $50,000. They awarded him less than that number. They awarded him less than that amount. Now, you're supposed to reverse these verdicts on damages if they shock your conscience. Now, trial counsel, in closing argument, said, look, he's 62 years old. There's no evidence that he was going to retire, but nobody works forever. You should award him damages to either 65 or 70. You make the decision, jury. And the number they awarded is right between those two. If you look at the 900...
Your argument is they just cut it in half.
Yeah, the jury did what was fair. The jury did what was reasonable. And what they didn't do is award him $600,000 or $700,000 like he was going to work till he was 95 years old. That might shock the conscience, but they didn't do that. Everything they did sort of made sense. Sort of made sense. Now, Your Honors, we think that the jury got the exact correct verdict. We don't think there's any problem with the decision of the jury at all, and we hope that you'll affirm the decision. And if there aren't any further questions, I'll take a seat.
Thank you so much.
Thank you.
Thank you, Your Honors. I would just like to point out a couple of things. First, with regard to the future medical expenses, Dr. Brooks's testimony as a pain management physician was that for pain management purposes, Mr. Clarke would need ongoing physical therapy at about $1,500 per year. Dr. Godleski's testimony...
Was that in relation to the herniated disc, the shoulder, and the hand, or some combination?
A combination, yes, for pain management.
Fixing the shoulder wouldn't necessarily resolve the neck issue, or wherever his herniation was.
Well, according to Dr. Godleski's testimony, and he was giving testimony, it's on page 342 of the supplemental record and 343, he testified that to do an arthroscopic exam of the shoulder, to do hand arthroscopic surgery, an evaluation from a hand surgeon, treatment regarding the neck, pain management, an estimate of the cost from review of the records, and from my own office, it would be a range of somewhere from $20,000 to $25,000, and that's a global number, depending on the location of the hospital. And that includes, he goes on and states that includes physical therapy following the treatment. Therefore, it was completely inconsistent with the evidence for the jury to award both of those costs. In addition, I would like to point out that you were correct that Mr. Clarke did testify as to his earnings in the past year. It was different each time he testified, and that was all relating to a single year, the year up to the time when the accident occurred. And therefore, there was insufficient evidence for the jury to reach the award that it did. And I would also like to point out the case of Laundromax, the recent 2011 decision out of the 3rd District Court of Appeal, where basically the 3rd District found that the evidence was insufficient, where there was no evidence of negligence on the part of the business owner. And I just wanted to point out that case because I think it's right on point with regard to the first issue. And we would ask, Your Honors, that this court reverse and grant a new trial on both liability and on the damages that we pointed out in our brief.
Thank you very much.
Thank you, Your Honors.
Thank you both. Have a great day and a safe trip home. conclude our session for the morning.